Hello, Mr. Delphine, and then we're back for another part in this series about the criminalization and victimization of the Marin County Courthouse. How you doing, sir?
I'm good, Reggie. How are you doing?
Oh, everything is great, sir. Anything you'd like to say before we get started?
Yes, thank you. In the name of Allah, the most benevolent, the most merciful, I would like to say that I don't work for legal advice. I don't give legal advice. This is for inspirational and educational and entertainment purposes only. I would like to say that I love my mother, love my father. I have love for the mother of our child, and I love our son.
Thank you, Mr. Delphine. So I see you are holding the article on the corruption that was printed in 2000 against the Marin County Courthouse and Judge Adams. Could you explain that with us?
Yes. This article was published in the SF Weekly called Odor in the Court by Matt Issac, Wednesday, October 18th, the year 2000.
Hey, can I get a shot of the front of that article?
Okay.
All right. Thank you, Mr. Delphine.
Oh, you're welcome. So this starts with Paul Camera, the late Paul Camera, who's the family law attorney in Marin County. And what happened was he had to recuse a judge by the name of Judge Michael Duffy, and they're longtime friends, and he had to recuse him for bias. So what happened was he asked him to recuse himself, and he did it, but there were some things that I'd like to mention about this article. So it was stating that Paul Camera entered Judge Michael Duffy's courtroom and noticed that the opposing attorney was Verna Adams, which is a judge now, and he had stated that Verna Adams had contributed to the campaign for Judge Michael Duffy, and they were close friends before the start of the trial. Judge Adams, or Verna Adams, denied the allegations of them knowing each other and didn't want to take the claim seriously.
And this Judge Adams is the one that's still practicing law in the Marin Courthouse as of today.
Yes, this, I believe, was a mentor. Judge Michael Duffy was a mentor of Judge Adams now, and she has learned from him on how to fix and rig cases and violate people's constitutional rights and decide cases in not by the law but by knowing and paying litigation fees. So in the article they were stating some about how the Paul Camera stated that if you were to go up against Verna Adams, you might as not well show up. So he stated that Verna Adams is representing the opposing side in Duffy's court, you might as well not show up. There was a lot of turmoil going on in this courtroom during this time, and it's still going on now. But this article is saying that the judge is not only the subject of a federal investigation, but also a recall effort based on charges that he and a small coterie of lawyers engaged in favoritism and ethical misconduct that ran roughshod over the justice system. Lawyers and litigants allege that Duffy and a close circle of his friends decided highly charged cases of child custody, divorce settlements, and inheritances, not only on merits but according to personal whims, friendships, and favors. So what this is saying is that Judge Michael Duffy would do favors for his friends that were attorneys on cases and not go by the law. So basically he was violating the canon laws, which is the laws of the judges to remain impartial and without bias. So it's also stating that this judge socialized with all of his friends and had wild parties at his vacation home, and had a group called the Fleas, the Family Law Lead Attorneys. And Judge Michael Duffy was not really a member after he became a judge, but he was more like the leader of the group. So with the family law lead attorneys, they are related to the Marin County Women Lawyers Group. So in my situation, the lady by the name of Johanna Kleppe, she was the attorney for the mother of our child. She belongs to this group, Marin County Women Lawyers Group, and together with Judge Adams, they fixed and rigged my case. And this is what is going on in this article, which is taking place now. So this article is also stating that Judge Michael Duffy gave special treatment to his friends in court that happened to be lawyers. These were some of the breaches and ethical boundaries, charges that he decided cases based on personal relationships, presiding over cases even though he had a direct and indirect financial ties with one of the attorneys. So under CCP 170.1 of California Code of Civil Procedure, that a judge is not supposed to hear a case where there's financial conflict. Hearing a large number of cases with his wife was working for the lawyers appearing before him. That's also a reason for the CCP to disqualify the judge. Hosting long weekends at his ranch, attended by a select group of attorneys, where court business was a regular topic of conversation, according to one of Duffy's closest confidants. So this is also a conflict of interest because this is confidential information and they shouldn't be talked about these things at parties. Catherine Shepard was a member of the Fleas, and she had provided some testimony of what was going on in the Marin County Superior Court. He said that organized in the early 80s, the Fleas hoped to promote collegiality and maybe drum up business for one another, and they would meet to discuss case law and do a lot of social things. They became like a clique. Okay, and they would meet at Judge Michael Duffy's sheep ranch.
So as of then and as of now, Judge Adams is still practicing the same corruptness that Judge Michael Duffy did back in 2000.
Yes, because I believe that he mentored her on the way to run the family court, and it shows bias. And even though this article, it was in 2000, the same stuff is taking place here in 2018 in the Marin County Family Court. It has been a lot of turmoil for people because they haven't been able to get fair trials or have their constitutional rights upheld due to these biases between these individuals, family law lead attorneys.
So it looks to me that Judge Adams is just picking up where Judge Michael Duffy left off.
Yes. The thing is that the children involved are being used almost like a collateral. So basically, they would find ways to litigate and file frivolous motions to make money. And then what would happen is they would also help each other with the campaign. So in the case of Verna Adams, before she was a judge, she was contributing money to the campaign, but that's like a bribe. It would be a bribe, but in a sense you say that it's donating money to the campaign. But Judge Michael Duffy groomed her on how to be a judge, and she followed after him as his predecessor.
And if it was worthy of FBI investigations and attention then, it seemed to me that it's worthy of an FBI investigation now.
Yes, the reason is that this is color of law. So you have judges like Verna Adams working in their private capacity, meaning they're working for themselves, and they're getting themselves rich and their friends rich through federal bonuses and excessive litigation. and they're using this family court as a platform to do criminal activities like RICO racketeering. One wouldn't think that because they always say in the best interest of the child, but if you research, you will see that everything is a commercial transaction. So for example, when they put a restraining order on an individual, they get funding for that. When they put people on child support, which is a state program under AB 1058, the state gets federal matching dollars or bonuses from the federal government at a rate of 66%. You have domestic violence groups that also work with the courts, and they get funding to give individuals free housing. So everything is all related, and they just run through this almost like it was a drive-through, like Jack in a Box. So basically, this article is very important because it shows that nothing has changed, and they're still doing this same conduct in Marin County Family Court. Instead of the family law lead attorneys, they have a group called Marin County Women's Group, and they work through that to fix and rid cases from my first-hand experience.
And in the meantime, in the between time, they are kidnapping kids, they are extorting money, and they are passing off fraudulent documents like you're about to show us now.
Yes, so thank you very much, Reggie.
Thank you, sir.
This is a tentative ruling from Judge Adams that was issued on October 19, 2018. So what happened was Judge Adams is saying to uphold the orders for child custody and visitation and allow the wraparound team to come in the father's home. This is stating by the order of probate code PR 180311, the minor's maternal grandparents have temporary guardianship of the child, and accordingly neither parent nor this court has authority to make decisions about the child's custody per family code 7505A. The two requests for orders are therefore off the calendar. So I will say that this tentative ruling is void ab initio. So void ab initio means void from the onset or void from the start. So what happened was with Judge Adams, she told the mother of our child's parents and their attorney to get a conservatorship, which is illegal under the Federal Rules of Civil Procedure, and a high misdemeanor that a judge is not supposed to practice law from the bench. And this is also a violation of one's due process. So this would be void. As stated, they make erroneous and void orders in the Marin County Superior Court, but they have played a cat and mouse game with me because they want me to petition the appellate court for the erroneous ruling. But the truth of the matter is that they should not make erroneous rulings or rulings that are not in accordance with the U.S. Constitution. So this is void. This here is an objection to this tentative ruling under 18 U.S. Code 241, conspiracy against rights, 18 U.S. Code 242, deprivation of rights under color of law. What's going on is that my rights are being violated, and I have many people conspiring that I don't get my rights that are upheld by the Constitution and granted by God. So basically, this is a way of Judge Adams terminating my parental rights. This is also stating that this tentative ruling that I just showed is void for lack of due process. And also for her colluding and coaching with Johanna Kleppe and the mother of our child's parents, where that's unlawful conduct, and whatever comes out of fraud fraud vitiates everything, meaning that once fraud touches something, it has to end in fraud. So once something has been touched by fraud, it can't be good. So the judgment created from the fraud and collusion would have to be set aside. But it can't be good at all. But it's just the issue of getting the appellate court to set the motions aside. It's a cat and mouse game, and the appellate court does not want to exercise the jurisdiction that they have. This was the motion to disqualify Commissioner Longaker pursuant to CCP 170.1, California Code of Civil Procedure. Those are reasons that you could disqualify a judge or commissioner for bias. So from what I'm saying is that Commissioner Longaker cannot be impartial and without bias, because the grant program 8B1058 pays this man's salary. And what's happening is that if the people are paying him, he's going to be in favor of them. So it's also a conflict of interest that this man hear the case. The child support is a grant program, and I was coerced into paying the people through a slew of false forgeries of court orders. I asked them to validate the debt. They never did. Everything that I asked them, they threatened to have me arrested and removed out of the court. So they were very biased and basically about getting the federal bonus dollars. So I recused this gentleman, Commissioner Longaker, and it caused confusion because he was stating that he was a commissioner. He was a child support commissioner. He was a judge. He was a pro tem judge, and he was a judicial officer. So when I researched that, under Government Code 1099, no person could hold two offices at once. So he would be a child support commissioner. So what happened was I disqualified him, and Judge Adams wrote the order striking the statement of my disqualifying him. And what's interesting about this is that, as I stated, Commissioner Longaker is quorum non-judice, meaning that he's not a judicial authority. He has no jurisdiction. So what happened was Judge Adams wrote this order striking the disqualification, but she did not sign it under penalty of perjury. So I don't know whether this is false or this is hearsay, but let me see here. Commissioner Longaker wrote verified answers of the Honorable Christopher Longaker. So one, he states, and this is all under penalty of perjury, I am a judicial officer of the Superior Court of California, County of Marin, and signed to preside over this case. So basically, he is saying he's a judicial officer, but then he works for the child support agency. These two issues are contradictions, because you can't hold two offices at once. He can't be a judicial officer and he can't work in the executive branch of government. So this is a false statement and or perjury. He also says, I specifically deny petitioner's claim and I'm biased against him. I'm not biased or prejudiced in favor of any party or attorney that's proceeding. These are also false statements, because he is going to be biased towards the people paying him. The court is paying him, the child support is paying him. These are the people that he works with. So this is also false. He says he can't have a reason why he cannot be fair and impartial. This is also a false statement. All his rulings made are based strictly upon facts and arguments officially presented to me and upon my understanding of the law. So when I stated to them the case law Freestone and Blessing and Supra, that the Supreme Court stated that the child support doesn't benefit custodial parents or children. It's a grant program. He ignored me. He also states that I am unable to admit or deny those allegations for lack of personal knowledge, or all other allegations which are related to me are specifically denied. So he's saying he doesn't want to admit or deny. This is also incompetence, because this man has this position and he doesn't have knowledge of what he's doing. And also he has a judge writing a motion to strike it. He can't write his own one, so this shows that he has no authority. He does not believe that his recusal will serve the interests of justice. The hearings of the child support are goes against the Constitution, because they don't allow a trial by jury under the 7th Amendment. So basically, this man, Commissioner Longaker, has made false statements under perjury, and I have broken down some of his points under the verified answer. So Judge Adams did not sign it under penalty of perjury, so that's false. These are false statements, and this is also considered perjury because I just proved that these are false. Okay, I also had to disqualify Judge Kelly Simmons. So once again, Judge Adams had coached and colluded with the attorney and the mother of our child's parents on how to gain a conservatorship over our child. Under the federal rules of procedure, civil procedure, a judge is not supposed to practice law from the bench. So she's giving advice from the bench on how to harm myself and harm our son. Judge Simmons from the probate court made a statement in the newspaper on how she thought that the trial by jury was her favorite part of the job because it's impartial and without bias. But when I entered her court, she was partial and biased and prejudiced against me. She wrote an order striking a challenge for cause against her, but she also did not write. She also did not write under penalty of perjury. So this could be taken as false or hearsay evidence, because when you write an affidavit, you write that under penalty of perjury, and an unrebutted affidavit stands as the truth. So she knew that if she signed it under penalty of perjury, she would be purging herself, because I alleged that her orders were void for fraud upon the court. She also refused me a trial by jury. And I also said that she's supporting the deceptive practices of Judge Adams and Johanna Kleppe. So if she had knowledge of that, she would ask for evidence and then be a finder of fact, but not just ignore the law. So she didn't answer the CCP properly. And this is the objection to her not signing the motion or the order striking my motion for disqualification. And I stated that she, I have no idea whether she's making true statements or making false statements, because she won't confirm that by oath. So her orders are also void for lack of due process and going against the Constitution. This is what happened was Judge Talamantes ended up hearing the cases for Judge Simmons. So I went to the court date in November, and she was not there. And Judge Talamantes replaced Judge Simmons. He was also present in the hearing when they put the false domestic violence restraining order on me, and he has personal knowledge of disputed evidentiary facts concerning the proceeding. He wouldn't remove himself off the case, and I had to file a CCP 170.1 due to him being biased and having personal knowledge of the case. So he wrote an order striking statement of disqualification, and he was stating that my declaration is flawed. He says that the disqualification does not reveal any grounds for disqualification on its face, and the judge can strike the statement of disqualification. The whole action is actually fraud because you have a family court judge giving advice to the opposing side, which violates the Equal Protection Clause of the U.S. Constitution.